So I've talked a lot about how Joe Biden has the ability through executive order to accomplish a lot of really top line progressive items, progressive goals ranging from Medicare for all to lowering drug and prescription drug prices to cancellation of all student loan debt, or 95% of it. He has the ability to do all this unilaterally. He doesn't need the Congress. And that's important that you guys know that, and that he be held to account to that standard, because the media is playing this weird double game of sort of during the primaries comparing him to FDR and saying, oh, Biden can be the new FDR, without actually paying any amount of coverage or attention to the fact that, well, he actually does have sweeping executive powers that he can wield in the same way that FDR did when he became president during a time of national crisis. Obviously, that was the Great Depression. Joe Biden now inheriting a depression mixed with a pandemic, a public health crisis, and in which he does have the ability to act unilaterally, as FDR did when he implemented a lot of his New Deal orders, which were done via executive action. Joe Biden does have the ability to actually govern in a way that FDR did, but the media is not talking about that. And I think it's important because, as you guys know, it's very likely that we end up in a situation after the Georgia runoffs in January where Republicans retain control of the Senate, in which case, you know, the potential for, with a Democratic president, for there to be partisan gridlock circa the last 2 years of the Obama administration or the last 2 years of the Trump administration, that likelihood is very high. And the Trump administration seems to be managing expectations accordingly. The Biden administration, excuse me. Did I say Trump? The Biden. Biden's rhetoric is talking about mentioning the House and how he's willing to work with the House on canceling student loan debt up to a point, only up to $10,000. So a means-tested, you know, half measure. He's not even talking about Medicare for all. He didn't run on Medicare for all, which is unfortunate given that it polled extremely popular, even in the primary states where he won, where he defeated Bernie. Every state from Florida and Arizona to Virginia, Alabama, Mississippi, Tennessee, Medicare for all. Medicare for all is an extremely popular position that polls, the last poll I saw, 70% favorability amongst Americans, including 48% of Republicans, 66% of independents, and 86% of Democrats. So for Joe Biden not to support that is just ridiculous. Of course, he's talking about some really, you know, wonky, technocratic, underwhelming expansion of the Affordable Care Act, which is obviously not proportional to the crisis at hand. As far as drug prices, I'm sure that Biden has emphasized to some degree some drugs here or there, which is typically the way the Democratic Party operates. Is they really arbitrarily pick and choose their spots on this drug or that drug. Obviously, we're expecting a vaccine to be released soon, or 3 of them for COVID, that we need to be broadly administered throughout the country, that we need to be free, and Biden has the potential to do that again through executive order. But these are things that I don't really hear Biden talking about, addressing directly. And if the rhetoric doesn't rise to the reality of the broad scope of his powers, which again, through the United States Constitution, the role of the president is described in Article 2 as to take care that the laws are faithfully executed. So Biden does have a mandate. He has a legal pretext through the Constitution to implement the laws that already exist, to see them through. So given that that's the mandate of the president through the Constitution, which is the supreme law of the land, and that's exactly what there's a precedent in the way that FDR governed for presidents actually governing unilaterally in many ways. and that the media is holding Biden up to that standard superficially, artificially. I mean, what is it about Biden exactly that would make them say that he's FDR-like? I mean, he certainly has not had that progressive platform to be compared to an FDR. But if you're going to bestow that level of hyperbole in a praiseworthy way, then I think it's only fair that he be held to account to that standard. And so I've talked about how you guys need to know what the reality is so that your expectations are adjusted accordingly. And, you know, if the Biden team is trying to lower your expectations, not to fall for it, to know that, you know, there's probably a double game going on in which they're creating plausible deniability, so that then if they inevitably underachieve or are not as ambitious, they can blame the same old partisan politics and, you know, party gridlock and, oh, it was out of my hands, when we all know that they're corrupt. And, you know, but then they can have a scapegoat and say, well, it's not that the Democrats are corrupt, it's that Republicans suck, etc. So you gotta know, you've got to adjust your expectations accordingly to what the reality of the situation is. And as I've talked about, David Dane and the team at the American Prospect really uncovered a series of really sweeping, up to 30 really substantive items, from breaking up the big banks and taking strong anti-monopoly actions to invoking the Affordable Care Act, a measure in the Affordable Care Act that allows for Medicare for all to be distributed, as has been the case for citizens in Libby, Montana, who were exposed to a public health crisis when asbestos exposed the town. You can invoke Section 1498 of the Federal Code to seize patents from drug manufacturers that try to gouge the market due to market monopoly, having exclusivity on a product, on a drug that they put out, a life-saving drug, a crucial drug, for a period of 20 years. Our patent protection, our intellectual property laws are really ridiculous and can be exploited easily for profit. But the government, there's a precedent where the government has stepped in again. After 9/11, Bayer distributed Cipro and tried to gouge the government. That was a drug that reversed the effects of anthrax, which we were going through an anthrax scare, and when the government stepped in and said, well, hey, listen, if you're not going to make this affordable, you know, we're trying to be reasonable here, but if you're not going to negotiate in good faith and you're going to try to gouge us for thousands of dollars or millions of dollars for a drug that we need, then how about we just compensate you for a fee, you know, buy you out, and basically take your drug and just give it, you know, sell it for $1 to everybody. And that's exactly what Bayer did. They caved. So again, there are historical precedents. The citizens of Louisiana a couple of years ago were exposed to hepatitis C, 35,000 people, and Gillette Science, the drug manufacturer, was trying to charge $85,000 a pop. So the government, there was an inquiry that was open. Well, can we do $14.98? And just the pressure of that, they caved. So anyway, there are historical precedents. There's a law in regards to canceling student loan debt that's actually been on the books since dating back to the Eisenhower administration, further codified into law with the Higher Education Act of 1965, which gives the president broad discretion to cancel all publicly owned student loan debt. And in fact, under the Obama administration, 95% of all student loan debt, 1.5 trillion of $1.6 trillion in total was bought out by the government. So the government basically owns all of your debt and can choose simply not to collect. This is something that, you know, if Biden just taps administration heads that are sympathetic to his to these items, to you know, being helpful and being a source for good, then he can easily accomplish all of this stuff. But what if he runs into the Supreme Court? What if Biden runs into a hostile Supreme Court, which obviously he will, because as you guys know, the Republicans, Mitch McConnell's political project has long been to stack it with really, capitalist tyrants, really libertarian types who are really hostile to workers' rights and democracy, really. You know, they just stacked the Supreme Court. As you guys know, Amy Coney Barrett just got there, giving conservatives a 6-3 majority. And what that means is that Biden faces an uphill climb, even if he does manage to advance any legislation, in not getting his agenda overturned by hostile conservatives who are basically, again, libertarian tyrants, just really hostile right-wing libertarian types who are totally just pro-capitalist and free market oriented, and want to shrink the government, and believe that they're entitled to do that because of the way that our two parties generally agree to outsource their governing agency to the courts, and basically just let them strike down at will, using the legal pretext of, constitutional or judicial review as an excuse, and when in fact that's something that's completely made up. The Supreme Court does not have that power. That is a myth that's rooted in not any legal or constitutional basis, but just mere self-dealing, just purely political. I mean, this is something, there's nothing in the Constitution that grants the Supreme Court the authority, the constitutional authority, to just simply strike down or check or review the legislative or the executive branches of government. You don't get to decide according to the Constitution if you're a bunch of unelected officials on a legal bench. You don't get to decide the laws. You don't get to rule. You don't get to govern as an unelectable body. That's something that actually dates back to the principle of judicial review. Is something that dates back to a Supreme Court decision. So again, it was a totally naked power grab, rooted in politics by the John Marshall Court in 1803, who did this really sneaky thing where the president at the time, the incumbent president, Thomas Jefferson, was hostile, was himself, felt the way that I do about the power of the Supreme Court, that it was totally fraudulent and ridiculous, that they should be able to veto or override the will of the people, right? So they understood that, and so what they did was, in one fell swoop, they just pulled out of the ether in Marbury. Marbury was the decision. They just decided that they ruled in such a way where they established, well, there's this law on the books that contradicts the Supreme Court, and then so you can't have that. The Supreme Court is the supreme law of the land. So they went ahead and in that moment established judicial review, but they ruled in such a way that favored Thomas Jefferson's agenda, that benefited his political agenda, so as to neutralize his objection to the principle. So it was a really sneaky thing where Jefferson went along with it, because even though he disagreed with them having that much power, he wanted to get his agenda enacted, and the court worked with him on that. And ever since then, there's been this just sort of tradition of our elected officials deferring to the Supreme Court on decisions. So that dates back to that John Marshall Court of 1803, and has basically held steady except for the time when Abraham Lincoln and the Republican Party, the recently formed Republican Party, at that time they were the radical left, challenged the Supreme Court's authority, again under the notion that wait a second, how do you as an unelected body of ideologues get to override the will of the people? And this was coming off of Dred Scott, the 1857 decision, in which they ruled that there were no rights, there were no constitutional rights that the black man had, that the white man was bound to recognize or respect. And we all know that Abraham Lincoln obviously ignored that, emancipated the slaves in 1863 with the Emancipation Proclamation, we all know that the Civil War was waged, the results of which was the Reconstruction era and the Reconstruction Amendments, the 13th Amendment abolishing slavery, the 14th Amendment establishing due process and equal protection under the law for freed slaves, and then of course the 15th Amendment, which was obviously enfranchisement, right? Voting rights, which we all know in practice and legalistically did not actually fully come into effect for another century. But at that time, for a short period in Reconstruction, there you go, freed black people were enfranchised, and they were able to vote, and so they got all these civil rights acts that flew directly in the face of the Supreme Court in Dred Scott, which basically tried to again be just really reactionary, racist, and wield their power, their authority over the will of the people. And they represented a minority view of the country, just as frankly the reactionary capitalist tyrannical Supreme Court of today represents a small minority of the country. That no one agrees with them on economics. You know what I mean? Like I said, this is a really sort of libertarian, totally tyrannical group of unelecteds who basically represent a very small faction of really right-leaning economics people in this country. And so given that they're not popular enough to actually, you know what I mean, be representative of the will of the people, I think it's incumbent that you guys know that there is a historical precedent under the Abe Lincoln administration that exists, under which Joe Biden could simply choose to ignore, sidestep, bypass the Supreme Court anytime that they come for his agenda. The explanation that I see tossed around by progressives, the solution, the proposal for getting around the Supreme Court is court packing, which is something that FDR tried unsuccessfully in 1935. Unsuccessful in the sense that he didn't get any bill to get through. He wanted to impose term limits. He wanted you to have to retire at a certain age. For every justice that turned 70, we could add an additional seat, etc. He didn't actually accomplish legally in getting through any of his aims because even his own party, the Democrats, opposed him in Congress. But the pressure, the public pressure, the concentrated public pressure, similar to the way Abraham Lincoln and the Republicans created concentrated public pressure, a mass public campaign to discredit and delegitimize the judicial supremacy of the Supreme Court, that forced the Supreme Court to sort of on their heels, that put them on defense, in which case they started to let FDR more or less govern to the will of the people, which was with the New Deal orders, which so there is a precedent for that as well with FDR. But the thing is, if you grant that court packing on principle is okay, then you're just sort of buying into the whole notion that it's okay to outsource democracy to, again, an unelected body of ideologues, so long as they agree with you on the issues. But how is that any different than the conservatives stacking the Supreme Court to their ends? We hate it when it's a bunch of unelecteds that are doing, deregulation and tax cuts, but when they're, working to serve, liberal causes, liberal ends on social justice issues like, equal protection under the law for, let's say, obviously desegregation under the Warren Court in the 60s, or for, marriage equality with Obergefell, basically just siding with them whenever they agree with us. It's kind of not only hypocritical, but it's just a really flawed thinking. I mean, the Supreme Court basically is ostensibly doing the will of the founders by abiding by the Constitution, but again, it doesn't really make sense. The Supreme Court contradicts itself all the time. This is something that Matt Brunig at the People's Policy Project talks about. He says, This is an extraordinary power that can be used to accomplish anything, whether good, bad, or indifferent. Talking about constitutional review, judicial review. You can use the power to say school segregation laws are disallowed, and Brown, Brown, 1954, or to say that school desegregation laws are disallowed, as in Parents Involved, 2007. You can use it to say laws restricting voting rights are disallowed, Harper, 1966, or to say that the Voting Rights Act is disallowed, Shelby County, 2013. Again, these are contradictions. You can use it to say laws restricting contraception are disallowed, as in Griswold, 1965, or to say that laws requiring insurance to cover contraception are disallowed, as in Burwell, 2014. You understand? These are all contradictions rooted in the political composition of the court at a given time. So different ideologies at different times are going to rule differently on social issues, or in some cases economic issues. Although I think there's generally been more of a consensus on economics on the bench, the Supreme Court, than with other issues. But things that were allowed, says Matt Brunig over at the People's Policy Project. I'm going to put the link to this article below the video. But it's things that were once allowed by the Supreme Court can later be disallowed. So at one point, you can say that campaign spending regulations are allowed, McConnell, 2003, and then say that they are disallowed, Citizens United, 2010. You can say that fair share fees for public sector unions are allowed, Abood, 1977, and then say they are disallowed. So you see what I'm saying? It's basically just a slippery slope. I mean, if you agree that the Supreme Court has the power, that the Supreme Court is that this argument of constitutional review is a good faith reading interpretation of the work that the Supreme Court does, then you're not serving that purpose by just simply continuing to playing this game where whichever party's in power, tries to overplay their hand by, creating, filling new seats or opening vacancies, packing the court. It's just a slippery slope that will never end. It's not going to accomplish ostensibly what you're claiming to want to accomplish, because, again, it's just all depends on the political composition of the court. And again, we have a historical precedent. I'm going to link at the bottom of this video a fantastic piece from Matt Karp over at Jacobin about how Abraham Lincoln fought the Supreme Court. So you understand about how the Supreme Court, how Abraham Lincoln and the Republicans waged at the time what was, as Matt Karp says, and I quote, perhaps the most aggressive popular attack on judicial supremacy in U.S. history. The court makes a decision, argued one New York legislator, but does not make the law. So this was a very strong, coordinated attack by the Republican Party and Abraham Lincoln in the run-up to his election in 1860. He was coming hard at the Supreme Court for Dred Scott during the debates in 1857. In 1858, when he was running, he gave an absolutely inspiring speech on his inauguration, in which he targeted the Supreme Court's power, how undemocratic the process was of just delegating that power, that responsibility of governance to the Supreme Court from a government didn't make any sense. How absurd the whole notion was. I'm trying to find a quote here. The court, Maine Senator Hannibal Hamlin, Lincoln's future vice president, offered a blanket rejection of the court's authority to decide a political question for us. We make the laws, they interpret them, but it is not for them to tell us what is a political constitutional right of this body. Of all the despotisms on earth, a judicial despotism is the worst. It is life state. These are some of the quotes that were coming out of the Republican Party, Lincoln's allies. I mean, they were attacked. I understand that this is controversial, for Biden to be sworn in and then immediately, say like, oh, the Supreme Court, I don't care, I don't care about your authority. Who cares what you have to say? I understand how that might even frighten some liberals who are, again, not accustomed to this way of thinking. But that's the whole point of the Abraham Lincoln story, is that this was once you get past the idea that the Supreme Court is a legitimate political body, or a legitimate, basically, substitute for Congress and an elected body of officials. Once you get over the notion that that is a democratic process, it's one that, again, originates from the Supreme Court in basically a straight up power grab, total self-dealing that came in 1803 under Thomas Jefferson's presidency. So once you realize that they're basically, oh my God, after Lincoln and Hamlin were elected in 1860, the new president's inaugural address articulated this view in perhaps the strongest language he ever used. If the policy of the government upon vital questions affecting the whole people is to be irrevocably fixed by decisions of the Supreme Court, the instant they are made, the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal. So really inspiring stuff. I'm going to post a link to the Jacobin piece from Matt Carve at the bottom of this video as well. I'm also going to link a piece from Ryan Cooper, Democrats Have a Better Option Than Court Packing, which he also talks about just ignore the courts. You know, this notion of, you know, Biden can come in and basically bypass the courts and dare them to stop you. Because if you're offering Medicare for all for the people or debt cancellation, the Supreme Court chimes in, you know, this is unconstitutional because blah, blah, blah. Just call them out on their bluff, man, and see if they're willing, see which way the political winds blow. And see if they're willing to, you can do a Voting Rights Act. You can do the strongest Voting Rights Act of all time. The Supreme Court gutted the Voting Rights Act in Shelby County. And I think many people, if they really fully appreciated how badly they set back voting rights in this, with the opening rights of suppression laws in southern states and red states with a history of discrimination prior to the passage of the Voting Rights Act of 1865, people understand the extent to which these problems still persist today. I think that, you know, that political pressure would put, again, the Supreme Court on their heels the way that Abraham Lincoln and these really bold, brave Republicans did at the end of the 1850s and in the lead up to the Civil War, in which time, again, they were all, their politics were represented a minority of people, which is why Abraham Lincoln is regarded as the greatest president, or one of them, in American history. But yeah, so I just want you guys to understand that this whole notion that the Supreme Court should legitimately preside over our government, you know, this bipartisan consensus that our corrupt parties have sort of tacitly, implicitly bought into, that their entire legislative agenda should be held to the whims of a bunch of, you know, ideologue, you know, tyrannical, you know, political, unelected ideologues. It's undemocratic, it's absurd, it's ridiculous, and honestly, it's no reason for Biden or for you guys to hold Biden to a lower standard. I mean, if Biden's going to be compared to FDR, and FDR did challenge the courts, not as aggressively as Lincoln, but he did challenge the courts, then it's only fair game to adjust your expectations accordingly, and to hold Biden to the standard, and to expect that, yes, and to push him to, you know, to lobby him to take on the Supreme Court, man. You know, don't roll over to the Supreme Court. Yeah.